National Heritage Resources Act. And so it's therefore important that you understand the sector broadly, but more specifically on how directly or indirectly this would have an impact on you and your operations as the Funeral Undertakers Associations. We will drill into the details as we go on to the graves so that we can look at that aspect that deals with the graves. And then we can look at the sort of accountability really between SARA and themselves as stakeholders that intersect with the sector in various times and spaces. By way of introduction, what is SARA? Some people, when you say SARA, they say who? You know, they think SARA is a person. It's not a person, it's an entity. SARA, S-A-H-R-A, is an acronym for the South African Heritage Resources Agency. SARA is a statutory organization that was established in terms of the National Heritage Resources Act 25 of as a body that is responsible for the protection of South Africa's cultural heritage resources. And as some of you may know, SARA replaced what was called the National Monuments Council in 1999. In the following year, SARA is 26 years old, and it is under the National Department of Sport, Arts and Culture. It's important to point out that SARA should not be confused with the National Heritage Council. It's a sister entity. It's a sister entity that is also under the Department of Sport, Arts and Culture, but has a different legislative mandate from SARA. So SARA is the regulatory authority when it comes to, and it's the only regulatory authority when it comes to this particular thing of administering the Act. Now, just perhaps to you on how SARA is made up, SARA has different units within it. And these units are all kind of focus on a different, I would say, section of the legislation in order to cover holistically the conservation of heritage. And so you have the APM unit, which is the short archaeology, meteorites, and paleontology unit. We have the burial grounds and graves. We have the built environment unit, development applications unit. And we have the unit. We have the heritage protection unit. We have the national inventory unit. We have the maritime and underwater cultural heritage unit. And then we have the repatriation and restitution office. You would find that particularly the development applications unit and the APM, the heritage protection and the RRO quite a bit intersect in a lot of the spaces. So that's how SARA is structured. So the burial grounds and graves unit would implement section 36. The development applications unit would implement section 38 and so on. The heritage objects unit is section 32 and so on and so on. So the variation are covered broadly within SARA. And what is then the role of SARA in terms of its legislative mandate? The role of SARA is to coordinate the identification, recording, and management of South Africa's heritage resources. Very, very important. And I think that when we say coordinate, it's important to then touch base with various stakeholders, both within the sector, but also some which we think may perhaps be the sector, and we have not brought them in order to loop everybody into this coordination of recording of the national estate. But also important to introduce an integrated system of identification, assessment, and management of heritage resources. Very, very important. SARA has done that where we need to know and whether they are being interfered with or they are moved and relocated from one point to another. To achieve that, there is a system that has been. Funeral undertaker associations are going to exhume and relocate that is protected by the Act. You would then have to comply with and follow through in your line of work. But also to encourage and promote public national heritage, and to assist, advise, and provide professional expertise to any authority responsible for national estate at provincial and at local level. Say that SARA manages within the 3 tiers of government: the national, the provincial, and the local. So with the national, SARA is the ministers, the heritage resources at a national level. Provincial heritage resources authorities, such as here in Gauteng, it's the Gauteng PRA. If you are in KwaZulu-Natal, AMAFA. If you are in the Western Cape, if you are in Limpopo, it's LIRA, Limpopo Heritage Resources Authority, etc. Those are the provincial ones. And then the local authorities would refer to the local municipalities. We work and intersect quite frequently with the municipalities as well. So I thought I should just maybe explain that and what it means, because what that means, doing work in, for example, there are certain applications that would not come to us as SARA, but that would go to AMAFA in KwaZulu-Natal. So that's very important. But also to monitor and ensure compliance, national principles, standards, and policies for heritage resources. Just to, without going into detail, which my colleagues are going to do, the legislative framework that exists, we have the National Heritage Resources Act 25 of 1999. And then we also have regulations. And in particular with graves, you can look at Chapter 9 and Chapter 11. They deal with the burial grounds and graves. But we also have the burial grounds and graves permitting policy that is available. But also, having said that, these are legislations that directly impact SARA and its operations and within SARA. But if you look outside, we don't just work alone. There are other set of legislations which I know that as funeral undertaker associations, you comply with, but may also intersect with SARA. For example, the National Health Act. The National Health Act was what was called the Human Tissue Act of 1983, right? So that was repealed and replaced by the National Health Act. So as you read through the legislation, it might say Human Tissue Act. It's now the National Health Act. And then we have the Commonwealth War Graves Act, right, of 1992. This relates to graves of people that died in the First and Second World War. Those graves are administered by the Commonwealth War Graves Act of 1992. And the Commonwealth War Graves Commission is an organization that we intersect with, and they are for those graves. And then also there are municipal bylaws on our cemeteries and also burials as well. So we must ensure that our legislation is in harmony, or whatever else we do is in harmony with all these legislations that I've just highlighted as an example. It's not exhaustive, but these are the primary ones that I have looked at. So, having said that, graves are an important part of our national estate and must be identified, documented, and conserved for posterity. And the question is, what is the national estate? As to a collection of heritage resources in their broad spectrum. And those heritage resources are, of course, of cultural significance and of cultural value that must be preserved for future generations. Now, we have buildings. As you know, buildings that are 60 years and older are automatically protected by the Act. Even if it's your house. If your house is, you cannot just knock it and just change it willy-nilly with the legislation. There are heritage objects. I talked about the heritage objects unit earlier. So there are heritage objects that are protected by the Act. Certain objects that are of national value cannot just be moved around willy-nilly, exported, and even sold willy-nilly, because that would constitute a breach of the legislation. Just some time ago, I don't remember, it was perhaps about 5 or so years ago, someone was scrolling through the internet and they came across the report of Steve Biko on sale online. Right? So, investigations had to be done to try and see how did it get where it was. Sarah works with the police as well to try and curb some of those. Some time ago, we also found an auction of archaeological stones. I don't know where this person picked them up, but they decided it was a good auction them, etc. So yeah, I'm just giving an example on heritage objects. And then we have archaeological sites as well that are protected by the Act. We have graves, burial grounds and graves. And we also have maritime and underwater cultural heritage. This is very, very important. Some of you may, in Limpopo, it's protected by the Act. It's a national heritage. Also got shipwrecks around the country that are protected as well. And therefore, the BGG unit, the Burial Grounds and Graves unit, focuses on the conservation of graves that do not Section 38. Now, Section 38 deals with large-scale developments, such as mining, township development, etc. So our unit has a very narrow Section 36, which is Burial Grounds and Graves, under the National Resources Act. I'm glad that we've got our colleagues from the Development Applications Unit who are going to just give you an idea on what Section 38 is and requirements that are required as well from there. And then within the Act, we have Section 3. Section 3 identifies the various categories of graves that are protected by the National Heritage Resources Act. Role becomes very, very important. And so Section 36, as you go on, so Section 3 says these are the graves you can consider that are protected, but then Section 36 then outlines the requirements or compliance requirements that are needed to effect the protection of those graves. These are the graves in terms of the Act. Ancestral graves are protected by the Act. You cannot exhume and move them without a requisite permit from SARA or from a provincial heritage resources authority. Graves and graves of traditional leaders, they are protected by the Act. You cannot tamper with those graves without a permit from SARA. Graves of victims of conflict. Graves of victims include those who died in any war within the borders of the Republic, including the anti-colonial wars that were fought. And so those are graves of victims of conflict. They are automatic National Heritage Resources Act. We have historical cemeteries, and then we have other graves that may not be covered by the National Health Act. For example, when you come across a grave that is perhaps a heap of stone, and it looks, well, you're not sure about age, the rule of thumb is that you automatically assume that it is 60 years and above until evidence to the contrary has been. This is to afford that grave protection while processes and verification is being done. All right. So, and then you have graves of people who, of individuals designated by a notice in a government gazette. And then very, very important, and this is where I think your role becomes important. And I think this forms the backdrop of why we've actually brought everybody together. It's graves that are outside a formal cemetery, which are 60 years and older. Increasingly, we are receiving requests from funeral workers who have been contracted by families to say, my grandfather was buried in Kalkfontein. I want him to move. I want to move him to Springfontein, where I am. What do I do? All right. So that's where I think that we found that there is a gap, because So we increasingly have a number of covered by the legislation as the years go by, and so will intersect with this particular section. And it would be important for you to at least have some information. All right. Moving on, the purpose of Section 36 within the National Heritage Resources Act to provide, therefore, a legislative framework for the protection of graves that are identified by the Act as being part of the national estate, and to but also it is to include the coordination and identification and introduction of management systems for such graves. And this is done through the regulations which are permits that are issued for you to be to effect the exhumation and relocation that you could be doing. And then we also assist in detailing must be undertaken. I know that my colleague Ms. Sengane is always assisting a number of funeral undertakers, particularly those that would like to relocate human remains, because they are unaware of the system, South African Heritage Information System, which is the one where the applications are made and where the permits are issued. So very, very important. It's important that you take note of that the system is there, it's online, it's available. That is where the things are done. And so SARA develops policies, regulations, issues guidelines and permits, etc. For graves. I think I'll just brush over it on some sections of the legislation, but I will not explain that much. But this one is the one which I think really, really impacts your work. Where a person may, without a permit issued by SARA or a provincial heritage resources authority, destroy, damage, alter, exhume, or remove from its original position, or the grave of a victim of conflict, or any burial ground or part thereof which contains such graves. B, destroy, damage, alter, exhume, remove from its original position, or otherwise disturb any grave or burial ground older than 60 years, which is outside a formal. If the grave is already within a municipal cemetery, already protected by the laws of that municipality. Unless it's a grave of a victim of conflict, I must emphasize that. Unless it's a grave of a victim of conflict, liberation struggle, or in the anti-colonial wars and they were buried there, you just need to comply with the municipality. But if it's a victim of conflict, you comply with the municipality and also comply with us. But if it's outside a formal cemetery, or a PRA is the primary go-to entity. It's very, very important, right? So, and this is where there's a build we are receiving from funeral and can you assist us with the process? We would like to do 1, 2, 3, and we then have to take them through that process. And also, please just note that if you see someone taking a metal detector to a cemetery, you can ask them, do you have a permit to do it? Please don't become party to, to those that go looking for money. Of damage to old graves. For some reason, some people believe gold coins. So we're seeing a lot of vandalism with people going to graves and doing metal detectors and digging for gold coins, and then leaving the human remains exposed. Leaving the human remains. So please ignore that the way that this is protected by you cannot do that without complying. And then you also have a part that deals with what to do in cases where you've got human remains that have been exposed. Very, very important, because normally people just run to the funeral undertaker and say, they are now bones here, what do we do? And the question is that how do you advise what in that process? And this is also outlined that need to be undertaken. Just know that subs has come in, cordon off the site, determine whether it's a crime scene or not. If it's not a crime scene, then heritage resources authorities take over, etc. And then you may then be that you have archaeologists that may be called in to intervene and assist. And then victims of conflict are defined. I think I don't need to go back over this one, but victims of conflict are defined in the National Heritage Resources Act. African War, those who in the liberation struggle, whether they are within or outside of the Republic. All right, very, very important. That Republic, I must say that I have colleagues from the Repatriation Office that are here. We are beginning to intersect with your sector in some of the projects that are being done. Of those who died in the liberation struggle, their exhumation and repatriation would be something that your sector would intersect with at some point. All right, so very, very important. And what are these developments that I talk about, which do not trigger Section 38 and would require the Development Applications Unit? You have family requests for exhumation and relocation, very, very important. This is a contributor. Accidentally exposed human remains in an area that's outside a big development. Let's say, for example, I had a picture here. All right, what you see on the top right hand side of the picture, that is in Hammanskraal, but it's in an informal settlement. So this person, these people moved into the area and started pitching the settlement. But this person wanted to build a house, and as they were digging, they came across human remains of a young girl. Those are the ones that you are seeing on the top. That's not a big scale. What do you do? Right? And so this is very, very important that there is a process that is followed. We have cases from the Northwest where someone is extending their house and they dig and they come across human remains. So those would come to us to assist you with the process, what needs to be done. And then we also look at graves that are protected by that have been declared as national heritage sites. For example, the grave of, say, Reverend Mahabane in Kronstadt, or the grave of Pixley Isagaseme, or the grave of Rahima Musa. Those are national heritage sites as an example. And also graves of victims of, this is a concentration camp cemetery, right? Those are graves that are protected by the Act, and we would intervene as SARA. Let me just come to this particular section. I think is very important, a shared responsibility. That funeral undertakers are an important stakeholder in the conservation of graves. Let me say that. We may not have contacted you in the past, and we recognize that it's a gap. Funeral undertakers are very important because they must, in a way, directly or indirectly, the NARA. And grounds and graves unit, graves that fall outside the municipal cemetery and do not trigger Section 38, those are graves that are of intense interest to us, because those graves require a process of compliance that is undertaken. And what we have done as SARA is that we have recognized that for families to move one person from a farm to a formal municipality, to hire a heritage specialist or an archaeologist, for them it would be very expensive. To allow them to hire funeral to assist them with that process, provided the funeral undertakers then comply with the legislation as I've just outlined. So we then have requirements, which my colleagues are going to expand on, requirements on what it is that you need to comply with for those graves to be exhumed and relocated. So this is very important, and that's where I think your sector is very, very, very pivotal. So you do in that sense with the exhumation, and therefore must comply with the NARA, or the National Heritage Resources Act. Funeral undertakers are hired by heritage specialists to do the exhumation under their supervision. So even then, it means that funeral undertakers will have to constantly intersect with the archaeologist who has been hired mining company that wants to relocate 20 graves, right? That's where I think that a bit of knowledge by the funeral undertakers will assist in making sure that there is better managed and implemented, complying with the NARA. And as I've said, these are usually requests for exhumation and relocation. So SARA permits them to use funeral undertakers. I've spoken. In a lot of instances are 60 years and older. Undertaker must comply with the NARA. I think we've looked at that. The indirect part of the compliance. There are general principles there of the heritage resource that are very important for you to be aware of in doing particular work that you are a critical part of. That we must then take into account all values and indigenous knowledge systems. So speaking to cultural sensitivity and awareness, but also inclusion and engagement of stakeholders. It's important, for example, as part of compliance, that we have proof that the family has that the grave must be moved and relocated. Of the management of, or rather, heritage resources must be presented for research, education, and tourism in a way that ensures dignity for the cultural values. Resources management must guard against the use of heritage purposes and political gain. That is in the legislation. The developer pays. In other words, it's not SARA that pays when there's a request for exhumation. It is the family that has requested the exhumation to be done. They are responsible for everything. If they must perform rituals, they carry that. All we want to do as SARA is to ensure that that grave, which is protected in terms of the Act, is handled with dignity and in a way that it can be verified. Let me give the challenge that is emerging, but perhaps it will speak to this point. One of the threats of litigations that we are seeing in the sector comes from graves. People are suing each other or coming to SARA with complaints that relates to graves, increasing. So, my grandfather was buried here 20 years back, and let me not mention names, but let me give you this case from Limpopo, in case I get sued too. But there is this case in Limpopo, dates back 21 years, 21 years. The community then, graves were exhumed, relocated, and reburied, and they are saying today, no, the process was not followed 20 years ago. Now, the systems we have today, such as SARIS, the South African Heritage, did not exist then. Now, trying to find the records and everything. I'm just giving this as an example that if the followed properly and we don't document everything that we are doing, you could sit as a funeral under 20 years from now with a complaint that you exhumed illegally a person from Farm A and you took them to a municipality without the permission of the family. And so I'm just giving this example that graves are a pressure point at this point. And sometimes you realize that there's a subtext. In other words, what's happening there has nothing to do with graves. A lot about that, right? Cost of exhumation, reburial, and any cultural rights that are required. The colonial and apartheid period also left a lot of families, as you know, people were forcibly removed and so on, died and were buried there. People left behind loved ones. And today people are coming back and claiming those graves. And in some instances, yes, it's been proven. And in some instances, it is proving to be a little bit more challenging. So we have those communities as well. And then as SARA, we also rehabilitate graves of victims of conflict. And we regulate the exhumation of graves that are known and unknown to contribute to symbolic restitution. And this is something that my colleagues, the RRO, are busy with, which is a restitution and repatriation of human remains. And then this speaks to, this is a part of the legislation that speaks to and the reburial of human remains within the Republic, especially those that died outside South Africa, for them to be repatriated back, particularly those that were involved in the liberation struggle. We've had a big project that was done, and a funeral undertaker was of great assistance in having 63 remains that were unethically collected, reburied in the. We were assisted by a funeral undertaker to repatriate the human remains of liberation struggle stalwarts from Zambia and Zimbabwe for reburial. To say, someone might say, how are we relevant to the sector? Right? Because that was perhaps a question. People felt that they might know you are relevant in the sector, in that sense. Well, these are the challenges that we have as I'm going to begin winding down. These are the challenges that we have. We have challenges of unauthorized. The picture that you are seeing there, which is at the bottom, I think I moved forward too quickly. What's happening in the sector, what we are beginning to see is the unethical, the unauthorized exhumations that have happened. So the picture on the bottom left, that you are seeing on the bottom left, of course, this relates to a Section 38 development, but this is a case where there was a graveyard, and this graveyard is on a land that was owned by a mine some time back, but that mine has allowed a farmer to farm, continue farming around them. But for some reason, someone went there, demolished and exhumed the human remains that were there and took them. And we don't know who it was. So we have challenges that relate to unauthorized exhumations. And maybe by bringing you into this discussion, we hope that with the members that you have that are under your fold, you can sensitize them to some of these challenges that we have. And then we have vandalism. I think this one you are aware, not in any way something that's related to your sector, but we're sharing it broadly. This is vandalism of graves that is happening throughout that we see. What we are seeing there is the grave of Reverend Mahabane in the Free State. It was rehabilitated and over during COVID-19 and the subsequent lockdowns that came, that grave of all its metal and other things. And those metals, as I speak to you, are gone at this point, that frame. So vandalism is a big one. And we have, and this is where perhaps information sharing also becomes important, the informal settlements that are developing. People come up without faith. So the pictures I've shared with you there, we went back to Hammarskraal, an informal road close to that settlement. People were driving all over, up and down. But what then happened is that it looks like there was a grave there, very old. And then it rained and the human remains were exposed. All right. So very important. This is a challenge that we are facing, that maybe by involving you in the sector, it might be helpful to also in the spaces where you as our communities on this. But you also have exposed human remains that are exposed due to weathering and other natural elements. And then lastly, funeral undertakers are an important stakeholder in the management of graves. And recognized this reality and commenced a process, and this is what we are doing, of engagement with the sector. And SARA is committed to communicating, that is information sharing, that will assist the funeral undertakers to also comply with provisions of the National Heritage Resources Act. So very, very important that whether you are complying directly or indirectly, we are committed to assisting you to be able to comply. And any questions, we are prepared to take you, to hold your hand and take you through our processes. But what we also envisage as an outcome of this is a guideline document that we will share with yourselves so that you can also then disseminate to your members in their various spaces to say, this is how the the National Heritage Resources Act affects you. This is how you must comply. These are the requirements. And from time to time, we will amend those guidelines. But I think it would be a useless effort for us to convene. And then after this, it's just, there's nothing that happens. So it's our view that there must be something that comes out of this as a product, which will empower yourselves, your associations, and your members in making sure that they are compliant with the National Heritage Resources Act. With that broad sweep, I would just like to say thank you very much. Thank
Thank you so much, Mr. Matida. Please give him another big round of applause. I think it was a very important presentation. He highlighted key issues. I think primarily is that every year, the inventory of these protected graves, these graves that you have to comply with, is growing. So very interestingly, it's now 2026. So any grave from 1966 and before has to fulfill these requirements that were painted out here. I think it was also an invitation to the sector that there is an opportunity for partnership, that you play a very important role in protecting South Africa's heritage. And I think ultimately these processes that were highlighted here protect both the funeral association members and the families that are making these requests, as well as the developers. So it's open to questions. Please, as I said, it's a safe space, no right or wrong answers. And ultimately, your questions will inform the guidelines that they're going to develop to provide with anyone here. So the floor is open. We will take questions if there are any. All right, we've got a hand there. Is there any other hands? I just want to acknowledge you, and then we'll bring the microphone. Okay, we can start with the gentleman. Okay, sure. Okay. Also, they're recording it. Yeah.
Is the regulations from SARA on a national basis, or is it brought down on the provincial basis? So if I do exhumation in Gauteng, will I have the same rules as when I do it in Limpopo? Is everybody got their own house rules, their own bylaws, or will it be same right for the country?
That's a very good question. Yeah, you can come on.
Thank you very much for that question. Because SARA is the national body, all the other regulations that are developed by PRAS are then subject to the National Heritage Resources Act. So they cannot be in conflict with the National Heritage Resources Act or the guidelines that SARA would have provided or issued out. The one way perhaps it's sort of a nuance would be the municipalities say the relocation is to a local municipality. You would have to study carefully the nuances on their requirements. But still in principle, there needs to be a consistency and harmony in terms of the principles, both from the national level and to a provincial level. And then lastly, to say that SARA is the one that then sets the standards, and then the PRAS would need to then comply. We've done that recently with Limpopo, the province of Limpopo, where we've been assisting them to develop their system so that they can then comply. That way, it then works better for yourselves. And then where there's a conflict, we are available to advise and assist and see how that can be done. Thanks.
Thank you so much. We're still taking questions. And maybe just to add, what's important to the guideline is that there are those provinces where SARA is issuing the permits, but there are those provinces that have competency to then, like Western Cape, for example, Limpopo recently, where you'll then apply to the province and not SARA. So I think in the guideline, it has to be clear as to when you're in Gauteng, you go here. If you're in the Northern Cape, you go there. Yeah. Thank you so much. All right, there's a hand over there.
Good morning.
Morning.
I think you alluded to us in relations to people were buried 60 years older, and there was a mining activity, for example, that was conducted. So now come a family member to that real site, supposedly the real site, and said, no, my great grandfather was buried here. So I need closure as to where is he buried. So now there's little resource to now provide that family member to say they were moved from this point to another point. So how do you bring closure to that kind of family to say, okay, the family member was then moved to that point, and there's little resource to provide to that family member. The family member needs a closure to them. So how do you then assist with that?
Thank you so much. I think you're asking a very important question because these are real life cases. Yeah, you can come.
Yeah, just to say, yeah, that's where the pressure point is, and my colleagues from the DAU will perhaps speak a little bit about this. That we have a lot of families that are coming to look for their loved ones. One of the ways in which SARA assists, and it's also limited because of the resources that are limited. It's when it comes to where families are unsure of where the person may be buried. We had a case years back in Limpopo where we had such an experience. And we commissioned a GPR, ground penetrating radar analysis, in an area where the family pointed out the person had been buried. The radar came back negative. And that report was submitted to the family to say it was not here. So that's one way in which families are assisted. But also in cases where it's an issue of resources, SARA is not able to really intervene in providing, say, financial assistance to families to be able to say, the person has been located and they are in a mine and they need to be moved. What may happen is that, and I think my colleague Sabelo will speak about this, is that generally when a mining area has been determined and they would like to embark on a process of commencing activities in that area, they are responsible for assisting families in exhuming and relocating and reburying their loved ones in a separate place. So mines would carry the cost, including of the rituals that are done to do that. I think it's a different case, especially when, say, mining activities commenced 20 years back, and the person comes and says, under this mine dump that has now been put here where my family is. That's a very difficult one. We normally refer those to the commission, CRL commission, rights commission, so that they can mediate and see how that is resolved. Yeah, I don't know whether I've answered things.
Thank you so much. It's very complex, and there's many different dynamics at each site, but these are the real life cases that you encounter, and they take many years to resolve. They end up at the public protector. So maybe also in his presentation, it's about getting it right the first time, so that in 10 years' time, you don't deal with these cases. All right, there's a hand over here. Someone online. Okay, let's take this gentleman first, and then we'll go online.
Thank you. Actually, I have quite a number of questions, but I'll
No, please go ahead.
I'll stick to the most pertinent ones. I think, just to add to that comment, in my experience, and Mr. Madida might have referenced some of our minds of 22 years ago, we follow the SARA process and instruct when we appoint undertakers to follow the SARA process, whether or not the graves are protected by the NARA. SARA is the only regulator that can guarantee records into the future of any activities that have taken place. So from my point of view, if any of the undertakers, if you haven't participated in or actively been involved in the SARA process, do so, because SARA guarantees that there's records, It protects you, it protects the family, and it protects the developer if you're looking for developer. The question I have, one of the questions I have though, is regarding ancestral graves. That's not clearly defined in the Act. How do you define ancestral graves? In my opinion, every single grave is an ancestral grave, especially if it's an elder person that have descendants. We err on the side of caution. Again, when we go into relocation, consider all graves are claimed as ancestral graves because they are families, descendant families, whether or not they are 60 years or older. But I think there's a gap in the Act in how ancestral graves are defined.
Thank you so much. I think that's a very, very important point that you've raised. You can come answer the question. I'll also give my input after.
Yeah, so when the questions are hotter, I will defer to my boss to answer. Yeah, you are right. I think Sarah we've provided input for the amendment of the legislation. Certainly, the legislation was proclaimed in 1999, and it has not been changed. And clearly, there have been movements in terms of the experience and its implementation on the ground. So that's very, very important that, yes, you are right to say that graves are connected to people. And therefore, those people that are now deceased are ancestors of those that are still alive. So that's very important. I think where it becomes a challenge is where the graves are sort of unclaimed or unknown, but they exist. Right? I think that was perhaps the rationale behind just putting a broad sweep, saying that those graves at some point belong to somebody, to try and protect those graves. I can say that, what you've just said now, the process really protects you. Here is an example that we had 3 years back. A particular individual or community wrote to the President of the Republic, copied the department, and copied Sarah and a number of people, and said, Sarah is violating our rights by allowing a particular heritage specialist in exhuming those graves. Fortunately, what we had done, the heritage specialist had come and said, these graves, no one has come forward to claim them. And we said to them, 300 of them. And he said, yes. He said, no, go back. Please. He was very upset with us, but we said, go back. Please just give us another, I know it's not legislative, but another 60 days of public participation would not harm. Just please. And he agreed. And then he was cited in that complaint. We were able to pull up the record to say this person went above and beyond in their public consultation process, and no one still came forward. And that proof was pulled out from the record and provided. And the complainants never came back with a follow-up query. And I'm emphasizing what he was saying. That compliance is very, very important. Even if no one has come forward to claim the graves, there has to be that particular process. Because ultimately someone down the line may claim, whether spuriously so or legitimately so. But at least you would have that to protect. I think that was just a precaution. And as the legislation is being amended, those things would perhaps become much more defined with time. Yeah, but you are right.
Thank you so much. And yeah, I think he's covered it thoroughly. It's the classifications, right? Victims of conflict, ancestral graves, etc. Ultimately, we know that there are these graves of significance, but all graves are significant. If your mother is buried somewhere, that's significant to you. What we are, I think, trying to guard against is those frivolous claims where someone can just claim any grave as their own, which is why the process becomes important. But I think you've covered it adequately. Thank you. All right, I think we've got a question online. Can you please invite them? Are we going to be able to hear them? All right. If you're online, please go ahead with your question. Unfortunately, I can't see the names right now. All right.
Can you hear me?
Okay. Yes, I can hear you. Please go ahead.
Can you hear me? Okay. My name is Rasmus Primula PC from the Northwest Province, Museums and Heritage Specialist. Comment. The three-tier system of managing and protecting heritage resources, particularly when we look at the local authorities, we seem to be focusing on municipalities, and I'm not sure if municipal bylaws consume the responsibility of traditional leadership, because traditional leadership, I should believe that they form part of the local authorities. And I suppose that's the gap that we are having in terms of management and protection of our heritage resources. And also our PRAs, including Sarah as well. We need to improve in bridging the gap in terms of capacitating our local authorities, particularly municipalities, you know. Also in terms of grading and declarations, you know, the sessions that we are having currently, if we can cascade that to our local authorities, I think we will be moving towards a wonderful direction. The question, I want to understand what qualifies as a formal cemetery. For example, you find graves in a township that are not fenced, dating back to the 1930s. Would we say those graves qualify as a formal cemetery? I give thanks.
Thank you so much for your comments. They are very much appreciated. I'll invite Mr. Matida first, and then I'll also give some input.
Thank you very much, Ndadem Lapisi, for that. I think it is certainly correct, because not all exhumed and relocated graves will go to a formal cemetery. Some will go to a village, which is under a traditional authority, right? And so we've got guidelines then to say that there must be permission that comes, a letter that comes from the traditional authority. And I think I'm getting into the specifics that my colleagues will talk about. A letter that comes from the traditional authority that says, yes, you can bury here, right? Or that says, yes, this exhumation can happen, so that we don't get accusations where people will accuse yourselves and also heritage specialists of burying someone in an area where they have not been authorized. So we require those as part of our compliance. So he is right, yes, traditional authorities to a degree indeed are also responsible for for granting permission for people to re-inter human remains that have been exhumed, and therefore they form part of the compliance process. And so if your work involves that overlap, it would be important. I think that the issue of really a formal cemetery, it says here, in terms of the legislation, it says a formal cemetery administered by a local authority. Very, very important that there is that caveat that there are those cemeteries that are old, which were formal cemeteries, but perhaps have fallen by the wayside over time. But you may find that there is no authority that's responsible for them. All right. But those where the local authority exists, there's got to be that compliance that follows through. And so Sarah's intervention would apply to those graves that are outside that formal cemetery. Even if those graves, as we are saying, that you can tell that this was a local community that was burying there, and et cetera, et cetera. I can give an example in the Eastern Cape with rural areas. In rural areas, you've got what are called they would be formal in the sense that the traditional leader has designated that this is the burial area for the community. You can't just bury everywhere. They do in other areas designate that it is a burial area for the community. So it may not be formal in that sense, but in the sense of really having GPS coordinates on where it starts, etc. But it is a designated area of burial. And if such areas exist, that date back to the 1930s, automatically they are protected by the Act, that one cannot just go there willy-nilly and interfere. I also take your recommendation of saying, let's empower our local municipalities. It is true that there is a gap, particularly when you come to the local level of government. And perhaps that's where we may need, we've had engagements with SALGA, and we still continue to work with our colleagues to be able to sensitize them on the importance of compliance when it comes to this. Thanks.
Thank you so much, Mr. Matida, and thank you for the question. Maybe just to add that for this particular session, we did want to focus on the funeral associations, and Mr. Matida did say this is not a one-off session. In the following years, there'll be other stakeholders, and I think the local authorities are a very important stakeholder. Thank you. All right, I'll take one more question if there is. If not, we'll wrap up session one. We'll break for tea, but I'll just give a chance to see if there's any hands. And if are there any hands online? All right. Okay, colleagues, this is not the only discussion we'll have today. Lots of time to chat. Please give Mr. Matida a very big round of applause. Okay, so we're still doing very good with time. It's now 11:35. Can we take 10 minutes and return at 11:45? So please grab some tea, water, bathroom break. At 10:45, we'll start with session two. All right, let's start settling down. All right, colleagues, let's start settling down. We'll be starting in a minute. All right, EP online. Good. Okay. All right, thank you so much. We're now going to be starting with session 2, which will look at applying the law. The session will be presented by my colleague, Ms. Nokukanya Kumalo over here and Ms. Reagile Sengange, who's over there. But she'll be taking part 2 of the session. So they'll be looking, again, Mr. Madida did a broad overview, and they'll just going, I think, a little bit more in depth with looking at the application of the law and how SARA processes these cases. So again, she'll do the presentation. I will then allow for a question and answer session. And following that, we'll then take a break for lunch. I do know that the bathroom is far, so maybe just allow an extra 5 or 10 minutes for that. But as I said, it's the same. It's a safe space. No right or wrong answers. Please engage as much as you can. If there's anything for clarity, please raise your hands. And without any further ado, please give a big round of applause for Ms. Khumalo.
Good morning, everyone. My name is Nobukanya Khumalo. My colleagues know me as Osabelo. Today, I'll be just talking briefly about Section 38 of our Act and how it relates to Section 36, as well as Section 35, and the work that we've been doing. So I'm currently a Senior Heritage Officer in the Development Applications Unit. This unit is very brand new. It was established around 2023. Just sorry. Apologies for the interruption. So just to briefly touch on our unit is brand new. It started around about 2023. But beforehand, the archaeology, paleontology, and meteorite unit used to deal with a lot of the development applications. And then later on in 2023, that's where the development applications was established to manage all development-related applications that SARA receives. That being, it's not only just the development applications, but the permits related to the development applications, including grave relocations and any archaeological mitigations that might occur because of interventions and mitigations that occur from development applications. So because I'm talking mostly to the undertakers, I understand there is a couple of heritage practitioners in our audience. This presentation in Section 38 is going to be very brief. I'm just going to talk lightly on the law itself and not go into deep detail. Section 38 of our Act is split mainly into 2 sections, which is Section 38.1 and Section 38.8. Section 38.1 stipulates the types of developments that trigger the need for an application to SARA. It specifies that any development longer than 300 meters, any development that's larger than 5,000 meters squared, or any development that involves rezoning of a land parcel that is over 10,000 meters squared requires an application to SARA, as well as the combination of 3 or more urbans or breaking up a land parcel into 3 or more urbans would require any developer for notifying SARA. And this is because these types of developments might have an impact in the landscape. but also as SARA, as the national body, we only deal with applications for provinces that have not been assessed to be fully competent to handle Section 30, Section 36, and 35 itself. But the provinces that are fully competent to handle these sections of the Act are the Western Cape, the Eastern Cape, and KZN. Section 36 is currently in a handover period phase for Section 36, which is the Limpopo province. So we still do the development applications on behalf of the Limpopo, mostly handle the grave relocations related to developments that stem from development applications under Section 36. But mostly, the bulk of the applications are for very large developments that trigger not just our act, but the National Environmental Management Act. And this is basically Section 38.8, where we as SARA are also a commenting authority. We do not have decision-making powers for issuing decisions for developments that are large-scale and trigger the National Environmental Management Act, or the Mineral Petroleum Development Resources Act, which is mostly all of the mining applications that we receive, trigger both the NEMA and the MPDRA. And these applications, where it falls under NEMA or the NPRDI, we, as a commenting authority, and comment, but these developments, all of them trigger a heritage impact assessment. And with these heritage impact assessments, this is the main way in which a lot of the heritage specialists, particularly, identify burial grounds and graves across the country that are not in municipalities. So our SARAS, which is our online platform where we process these applications, also acts as a tree, and this is a map of South Africa and all of the development applications that we received since 2013, which was the first launch of SARAS. And this map, we also use it to neighboring applications or development applications that change how we consider the conservation of heritage sites in that given area. Heritage impact assessments, like I briefly said, are the main driver and mechanisms for SARA to actually record or have a record or last record of any heritage sites that are identified that might be impacted by development applications. And like I said, development applications have the potential Okay, so heritage impact assessment reports that are by specialists. So if a developer is wishing to develop within the parameters that are given that I've presented earlier, or a impact assessment specialist who has been appointed by a developer, say a mine company, they would appoint a heritage specialist, be it an archaeologist or say a town planner with a background in heritage, would be appointed to do a heritage impact assessment. The person who is appointed to do a heritage impact assessment is also responsible for undertaking other specialist studies within the heritage impact, within the heritage industry, be it a grave assessment, Stone Age assessment. There would also be built environmental assessments, cultural landscape assessments. All these specialists would be appointed and fall underneath or contribute to the overall heritage impact assessment report. As the Heritage Impact Assessment Report aims to identify. The main aim is to also provide mitigation measures if ever there are any impacts to heritage resources, including burial grounds and graves. They also need to provide conservation measures, mitigation measures, clearly stipulated within the report, and then submit that report to SARA for the provinces that we provide comments on, or to say the Cape, Amafa KZN in KZN, and the EC Provincial Heritage Resources Authority. Okay. So, given all the comments that we issue would also stipulate any conditions that we set to any of the developments. So, if that will be impacted, say burial grounds, we could either say that the scope of the development needs to change in order to conserve the heritage sites in place, or we could recommend that a permit application in order to have a final record of that heritage site and to mitigate that site before that area is impacted or cleared by the development. A specialist is because the specialist is trained in order to identify all types of heritage. And in most instances, an archaeologist is appointed because they have the expertise to identify many types of heritage resources, especially burial grounds and graves. Burial grounds and graves in South Africa can appear in many different ways, be within a former cemetery or within a landscape that looks exactly like what we'd expect today a burial grounds to look like these images in this presentation, where you can see delineated graves, or you can see monuments to victims of conflict, and it's clearly visible on the landscape. Or they could to the landscape, or graves that occur within pre-colonial settlements where it could be infant burials that are buried beneath house floors, or it could be isolated graves that are stones are used to demarcate that burial ground, or it could just be grasslands themselves. But also, the main objective of a heritage impact assessment is to also do some form of preliminary local consultation with the local community to understand the different types of heritage resources that occur in the landscape and to have that record in place. So, leading on to after a development application and a heritage site needs to be mitigated, or a burial ground needs to be mitigated, be it a grave relocation or a repair, to have a permit application that is submitted to SARA on from SARAS. And these are the requirements. So for any graves, especially development related graves, we follow in our regulations, which is the chapter 10 and chapter 11 of our regulations, the NARA regulations, which were gazetted in June of 2000. And SARA, as it was stated by Nopita, is that we deal with graves that are older than 60 years. Permitted under section 34, the provinces in Northwest. Application fee tends to be 5,000 Rand for relocation. And the permit is usually awarded to an archaeologist that was appointed by the developer themselves. And that archaeologist is responsible for submitting the application on SARS, a grave register within the motivational report, submitted to SARA on the permit application, along with affidavits of the consent from the identified families that have come forward after a social consultation period and have provided consent that their graves can be relocated to a formal cemetery. A formal cemetery could be a cemetery managed by the local tribal authority. If it's a cemetery managed by the local, obtain information on how many of the graves they're going to cemetery. So a application putting multiple says that are willing to accept this is especially for large applications. So if a development requires to remove a large subject breast, say plus minus 20 and above, and the families that have come to different types of cemeteries appear within the local municipality or the tribal landscape settlement. Of where graves that are being relocated are now placed at. We also require, not because of the regulations from SARA, but because the present when a gravement has actually spoken to the local municipality and gotten a house permit, has actually notified the police that they could be present, and also willing to have. These are not the only applications that we receive that are related to burial ground. Sometimes, like I said, in a heritage impact assessment, you identify areas that most likely look like a burial ground, but actually do not look like a burial ground in the typical sense. And we're not sure if there's actual graves in that given area. Issued under Section 35 of our Act. And the reason for consultation underneath Section 35, Section 35 mainly governs for archaeological sites, paleontological sites, and there, the Act stipulates that a site is considered an archaeological site if it's older than 100 years. And there, in the Act itself, there's an assumption, a general assumption that any site that's over ground, that is not the case itself. Sometimes there is living memory where local communities remember their heritage within a given area over 100 years. But the Act allows for, say, test excavations to explore if there is a grave without consultation. But now, grave comes into place. The environmental practitioner, if it's a development subject to an EIA process, already has been speaking to the local community in process, and the local community is aware of a development occurring, and they're aware of certain things that are happening in the landscape, and they, in short, we could consider that the local communities are aware of, can also provide evidence that there's some form of that instance, we do require some form of affidavit or letter of consent from the local communities to say that, so that we have in that process, if it is determined a burial is occurs within the landscape, then the developer and the heritage specialist can go ahead. In this instance, if there is a burial ground and grave, and then for a 36 application, we know for sure the grave, and we only issue a permit for a definite grave, and the grave there needs to be evidence. So once a permit application has been issued, and also expect a final report to be located with images of the grave. But to go into detail on the consultation period. The consultation period happens before a permit application is ever submitted to SARA for processing and consideration. The NARA regulations, and this is to either place a newspaper advert within the local newspaper. They have informal graves or cemetery that may be impacted by the developments they attain. It would be developed by the specialists. They would also be liable to appoint the undertakers who would be the responsibility to transport any graves that are relocated from a given area to the area. All of this information the information on how the consultation has occurred, understand that the issuing a permit that could be legally binding in case in the future any family member not aware of any grave relocation happening, we have any proof of it within the permit application itself. The affidavit of consent comes after the consultation. You know, once there's families that have, I know is not specific on how this consent happens. Currently, we work on the families having an affidavit to state that they are the legal family to responsibility because they are the claim. For example, we do not require any other further investigation because that currently is not stipulated within our act. We currently work off to claim a grant all in consideration. The heritage practitioner or the person who is the holder of the permit is responsible for the families that the actual relocation permit has been issued. They have 5 days to inform the families because in our act, any person has the ability or the right to appeal against any permit that has been issued. 14 days is the 5 days for the families to be informed that a permit has been issued is included within the 14 days. And currently, as it stands, our act does not have a condemnation period. That needs to be considered if ever the act is amended. But families have a strict 14 days in order to lay an appeal against any permit that is issued by SARA. And that appeal can be submitted by email with contact details provided inside the permit that is given by the specialist that needs to be communicated to the families themselves, made to our SARA council, because as we process the application, we cannot legally be the one to also against the decisions we have made. The appeal is sent to our council for consideration and is considered the first step within a legal process for appealing any decision that is by a department itself. Higher than the council would probably be the minister before going to the court system. But also briefly, I would like to showcase how the permit application would look like on SARS. So SARS, like I said, is a digital platform we work on. All our applications are on SARS. It is the last record of any heritage site that is identified within the heritage report. We also have like an extraction project that is taking out or recording any heritage sites within heritage impact assessment reports and then loading it onto SARS as a heritage site. When you first go onto SARS, you will see this page. And if you're a first time applicant, you have never used SARS, you also need to register a profile. So you have to click on to actually create a profile of yourself with an email address. Would ideally like it to be a company so that if it's a company with more than one member, the profile is not linked to one individual but a company, and it's if that individual leaves the company. Once you've registered a profile, our national inventory unit is the content moderators of the site. They're the ones who will approve your profile. And then once your profile is approved, this is how SARS would look like. And then you can always go to your dashboard at the right-hand corner to dashboard and see all of the applications underneath your profile. Or when you're the first time using SARS, you can go to the application selector at the corner like this, and you can see applications selector, and you go into this to create any application. Depending if it's a development application, a permit application, all of our applications would be created on the application selector. You would have to define what you want to create on SARS. You create a permit, which you'd say apply for a permit. If you wanting to extend a permit because you have not completed any of the work you've applied for or received permit for, you'd actually select in the instance if it's the first time applying for a permit, you say apply for a permit. And then you have to define the permit type. So you have to define the permit type, whether it's a Section 36 permit application, 5 permit application, and also define the province this application is for. Because if you select the province Western Cape, the application will not be visible to any SARA applicants, employees. If you select Eastern Cape, the application will not be visible to SARA. It will not be visible to any of the employees. It will be only visible to people on the east. But for provinces that are managed by SARA, the form is visible to all employees who are heritage officers at SARA to actually select themselves as case officers. And then once you've selected the type of application you've done and the province, you have to select the form. So you will select the form for the permit application for a formally protected if a site is formally declared as a national heritage site or a provincial heritage site. But for grave relocations, this would not be the form burial grounds and graves, and that you click on it and it will open a window up for you to fill in details about the project you want to undertake, upload any of the documents, including the motivational report, letter from SAPS, the landowner permission onto that form in order to create the case. There is a form where it gives you a submission ID. That's the reference you use to do the payment. And once you have the proof of payment, you upload it to the case before you click submit itself. And I think that is all for today for me on my behalf. And any questions that differ from a development application, Section 36 application for family members who just wish for themselves will be covered by Relocation.
Right, thank you so much. So that's part one of the session. I'm now going to invite Reachile up to cover part two, and then we'll have our Q&A on the two presentations. Can please give her a big round of applause. Right, and can I just get some assistance so we don't have the same issues with the HDMI?
My apologies, colleagues. It seems like the spirits of Freedom Park do not want me to present today. Please bear with me. Good day, colleagues. All funeral undertakers, heritage practitioners, invited guests, and members of the public joining us online and in person. My colleagues from SARA, welcome everybody. My name is Reachile Sengani. Everybody knows me as Ria. I am a heritage officer within the Burial Grounds and Graves Unit. I work under Mr. Madida, and I am the permitting officer within our unit. Before I get into my presentation, I would also like to thank Ms. Kumalo for presenting and for setting the foundation for our session's discussion on permit applications relating to exhumations and relocations of graves. In my presentation, I'll be focusing on exhumation and relocation permit applications that fall under the legislative framework. They're starting again. We're back on again, guys. Please bear with me today. We work with, uh, yes, I have already. I will be presenting on exhumation and relocation permit applications that fall under the legislative framework of Section 36 of the National Heritage Resources Act, specifically within the Burial Grounds Graves Unit. Unlike BGG, my apologies, DAU, BGG deals with non-development applications. As you can see on screen, these are the objectives that I'll be aiming for. I'll be giving you an overview of the types of cases that we deal with in terms of exhumations and relocations within our unit. And I'll also be looking at the different requirements that we have in terms of the different cases that we have and the processes that go with them. Within those processes and requirements, there's the consultation and public participation requirements as well. I'll be giving you information on the supporting documentation that we also require for our permit applications, and I'll also be discussing the conditions commonly stipulated when permits are approved and the responsibilities of permit holders. On top of that, I'll give you some examples of applications, why they delayed, returned, and require additional information before a decision can be made. Before discussing the various categories of exhumation and relocation applications assessed by our unit, it is important to understand the legislative framework that guides decision making. A fundamental principle of heritage management is that the identification of a grave does not automatically justify its relocation. The preferred approach is always to consider whether a grave can be protected and conserved in situ before relocation is contemplated. While this principle informs all heritage management decisions relating to burial grounds and graves, units is most commonly applications involving exhumation and relocation of graves. As such, this presentation will be focusing on legislative and procedural requirements associated with applications. As you can see on the screen, I have included the framework, no, there we go, that we use within our unit in terms of exhumations and relocations. The NARA is one. We also have SARA permit regulations. We have SARA burial grounds and graves permitting policies. And together, instruments establish the procedures and requirements to exhumation and relocation permit applications. On top of this, oh, it took the hammer. Bear with me, guys. The spirits are in the air. But I know that both my colleagues have already stipulated a lot of information on both the acts, and I too can go into it. But let me tell you about the most sections that actually mandate our exhumation and relocation permits. In terms of section 36.3, no person may, without a permit issued by SARA or the relevant authority, damage, move, or otherwise disturb older than 60 years situated outside a former municipal cemetery. Other applicable legislation, depending on the circumstances, may also be required with municipal cemetery regulations. As my colleagues have said, I'm not going to go into detail about it. But the one point that I want to say is that the national places a responsibility on to conserve and protect certain categories, which they have preserved, of burial grounds and graves. Consequently, relocation, alteration only proceed once the required permits have been obtained and the necessary consultation processes have been completed. Before introducing the key question, my apologies, the thirst is getting to me because of the spirits in the air. Before I get into my next, which is going to be dealing with the different cases that we deal with our permits, I would like to pose this key question. Different graves require different relocation processes, but how do we determine which processes apply? The answer lies in the category and heritage status of the graves. Let's examine the most common exhumation cases encountered by units. The first common one is exhumation and it's a movie. Okay. Let me just move to the next slide. Yeah, I was not present today. The first case that I was going to be dealing with was family. Colleagues, it's not moving. The slide is not even showing properly. Unnecessary.
All right, colleagues, I do apologize. Please give Ms. Riachile a big round of applause. Um, okay. Yes, 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 Mr. Matida Kolosh. So it happens now and then. I'm so sorry for the technical difficulties and apologies to you as well, colleagues. What we've decided for the sake of time, because it's now taken quite a while, it's taken all her presentation time and it's supposed to be lunch now. She's going to share the presentation with everyone. As we said earlier, there's going to be outcomes, there's going to be a guideline that is formed from this, and the presentations from today will be shared. So she will just put it in a PDF, and at the end of today's session, she will share that with you. It does have a lot of important information that speaks to the processes, so it's better that you have that information on hand. But I just want to make sure that we do finish on time as well today. So please give her a big round of applause. Right, I'm just gonna get my notes. I'll allow one or two questions before we go for lunch. Of course, there was also Sabelo's presentation, but yeah, Mr. Matida.
Thanks. Just to perhaps, I know that colleagues will receive the presentation. Just to indicate that one of the important things that we needed to get was the types of permits that you apply for. Very, very important. And for you, here the exhumation and relocation permit is the one that is critical and key, because you will be applying to exhume and relocate human remains from one point to another. The other permit that you perhaps will come across as a request from families is the one of rescue, right? You would have to apply for a rescue permit. In other words, when human remains are exposed, a person is extending their house and so on. We can't, it's difficult to say to the family, get a heritage specialist, because they might not be able to afford it. We've had such a case in the Northwest. However, you would, perhaps that's a permit that's very important, which may impact you when you are requested to assist in the rescue of human remains. So it's very, very important that you take that into cognizance. And then the other points as well that relate to things that perhaps impact yourselves are the requirements that she was outlining. There is a payment for her for development applications. The payment was 5,000, but for families, it's 1,200. It is standard, right? So even if they are moving two graves, it's not 1,200 per grave. It's 1,200 for the process, right? So yeah, so very, very important. Extensions are available in a similar manner. Say, sometimes fights break out within families, right? And then there's a dispute and you are stuck there. And then your permit expires while the family hasn't resolved their issues. Then there is that issue where you can also ask for an extension. So very, very important. The other requirements are the letters from the traditional authority if you are burying outside a formal municipality. And then the letter of the landowner where you are exhuming. So if it's a farm owner, the farm owner must authorize. If it's under the traditional authority, they must authorize. So you need to get those letters in. And then, of course, there's the payment that must be done of 1,200, and then the processing can be done. Permits are not processed before that proof of payment is submitted. And so to avoid delays, because sometimes someone might say, why are there delays? Maybe that you perhaps have not uploaded some of the documents correctly. I just had feedback from one of the people here in the session. She's had an interaction with Ms. Sengane, and she's very patient. I can tell you that she can take you through the process just for you to ensure that you are compliant. But in a nutshell, there are those compliance requirements that are still expected from the funeral undertakers in order for that permit to be issued. And all this happens online, right? If your documents are compliant, we have no reason to hold the permit back. We absolutely have no reason to hold the permit back. Some of you who have interacted with us will know that within a week or less, we can issue a permit if documents are compliant, all right? It's only when there are outstanding documents and issues that we are unable to process it, and therefore we hold back the issue of the permit. Thanks. I thought I should maybe just cover those which would be covered in the notes. But if there are questions, we are still available. Thanks.
Thank you so much. Please give him a big round of applause for his second presentation today. But anyway, I'll take one or two questions very quickly if there are any. I think Mr. Madida covered all the very pertinent points. Again, the presentation will be shared so that you know which types of permits to apply for, any important information. So if there are any questions, I'll just allow for one or two. We've got the gentleman there, very quickly.
Sorry, just a quick practical question. We've heard the words disturb and the alteration raised a lot of times in this last session. Does that also apply for if I want to repair a grave? Like the tombstone fall over or the grave has sunken in, I have to fill it up. Does this also apply to the repair of a grave? Is that also seen as disturbance of the grave?
Thank you. That's a very good question. Who wants to take it? Okay, let's give Sabino.
Yep. Alterations of any graves also require a permit application. I'm assuming that if it's a grave younger than 60 years, you would have informed the municipality that work is going to be done. And I also have recent experience where we were repairing a grave. It was younger than 60 years. We informed the municipality, and the municipality knew on the day that we were coming in. But for graves older than 60 years, we'd also need to inform Sarah and get a permit application for alterations themselves. I haven't received much of those applications because they're generally not development related. But we've also had experiences with also repairs to memorial sites themselves that are memorials of graves. We're repairing them as well, that we get informed there's a permit application that's supposed to process, and then that the permit holder will be responsible for the quality of the work, who's on site, and who's also doing the work, and that the work is being done according to the laws, and that every party is informed. You know, every government department that works with burial grounds is informed as well.
Thank you so much. I'll take one more question if there are any. If you're online, covered? All right. Is there one online? Okay, if you're online, you can please go ahead with your comment or question. We can, I can't see the name, but we can hear you.
Can I proceed?
Yes, please proceed.
Ms. Rasmulapisi again.
Yes.
Regarding the significance of graves, even though the subject may not be so much relevant, the three criteria that we use. Let's say a grave has a local significance. Can somebody apply to a local authority for that particular grave or graveyard to be graded as grade 3, for example? I give thanks.
All right, thank you so much. Who wants to take that? Mr. Matida? Okay, Reakile? Yeah. Okay, you can start it and then Mr. Matida.
Definitely, yes, you can. We have worked in numerous projects where we have sites that are actually locally, significant within that specific location or province. And people actually come through and ask us to nominate, and we actually let them know that you yourself are welcome to nominate a burial place or a grave yourself, and you go through us, and it will help you through the process. There's a form that you have to fill in. You have to also be able to have approvals from also your local municipalities to see if they are on board, because now our process have changed in terms of grading and declarations. Now you able to prove that you'll be able to maintain and be responsible for the site in itself if it is graded to a higher, status. It needs to have like a heritage agreement in most cases, which is most preferred than a conservation management plan. But yeah, other than that, the main point is that anybody is able to actually nominate a site to be declared. You just need to be able to motivate to show us what is the significance about that site, and also if it is provincially or nationally significant, you need to motivate and provide evidence for that. Thank you.
Thank you so much. I think she covered it. Anything to add?
Yeah, just to say that I think this speaks to a point that you raised earlier on, Remulapisi, about the sort of capacity of local authorities. But 10 years nominated site for it to be graded locally and it becomes a local heritage site as opposed to a provincial or national. It is. It's just that I think at the moment the challenge you raised earlier on about the incapacity of our local authorities, which is something that certainly needs to be looked into, is something that I think can be done. Yes, the site can be declared as a local heritage site. The legislation does support you in that.
Thank you so much. All right, I don't see any other hands in the audience as well. So colleagues, I think it's everyone's favorite part of the day. It's lunch. So if you could please just step outside, they will direct you as to where we're having lunch. It'll be 30 minutes. I I know it might be a bit of a walk, and then we have one more session for the day. So let's go to lunch and try to get back by 3:30. I'll allow about 5 or 10 minutes because of the, sorry, 1:30. Not that 1:30. And again, we'll try to start at about 1:35, 1:40. All right. Okay. All right, colleagues, let's start settling down. We'll be starting in 1 minute. It's more than a pleasure. Sure. 1 minute, let's start settling down. All right, we'll be starting shortly. Let's start settling down. We'll just give another minute for the colleagues to come inside. I hope you all had a good lunch. The gentleman at the back on the left, sorry, so what's your name? Vili. So Vili said if we serve food like this, he'll come back every year. So, so Reakile, just note the menu, ne? Same food next year, they'll all be here. All right, thank you so much for your participation thus far. You guys are actually such a lovely audience. Please give yourselves a round of applause. And this brings us to our last session for today, which is going to be presented by my colleague, Ms. Kim Ngobeni, and she'll be talking about compliance and consequences. All right, so there are times where developers, sometimes the community themselves, family members, etc., do not follow the legislative prescripts that were presented today. So Kim is from our Heritage Protection Unit. They are the ones who investigate any contraventions on the NARA. Please give her a very big round of applause. And following her session, we'll have a quick Q&A, which will bring us to the conclusion for today. Over to you, Kim.
Thank you, Program Director. Good afternoon. I promise to be very brief. I think we all actually that presentation after lunch. So yes, good afternoon to all of you here. My name is Kim Ngobeni. I am the Senior Heritage Officer within the Heritage Protection Unit. So you can call us the Heritage Police, because that's basically what we do. Okay, so the Heritage Protection Unit, we assist all units. We work together with the APM unit, the Archaeological, Paleontological, and Meteorite unit. We also work with Maritime Underwater Cultural Heritage Unit. We also work with the Built Environment Unit, BEU. We also work with the Heritage Objects Unit, and more especially the Burial Grounds and Graves Unit. So the Heritage Protection Unit is responsible for ensuring that there is compliance, and we do investigations in conjunction with the other relative units. So the Heritage Protection Unit. So within the Heritage Protection Unit, we have two divisions. One division is for grading and declarations. So we had the colleagues speaking about national heritage sites, provincial heritage sites, and your local heritage sites, which is your grade 1, grade 2, and grade 3. So as we know that Sarah is responsible for grading and declaring. Another division, which we are going to, Heritage Inspectorate Division. So the Heritage Inspectorate Division is established in terms of Section 50 of the National Heritage Resources. So we're going to refer to the NARA, as you have colleagues speaking. We call it the NARA, that is our Bible within heritage. So as stated, in terms of the legislative framework, we are mandated by the National Heritage Resources Act 25 of 1999. And as part of that, Section 45 allows us to issue compulsory repair orders. Section 50, we're going to outline the powers of an inspector. And Section 51 will be discussing the penalties thereof. So we also work in conjunction with the promotion of Administrative Justice Act to ensure that all procedures and case decisions are fair and procedural. We also work with the National Environmental Management Act. As we know, we are dealing with developments, and there are processes that need to be followed in terms of the legislative framework. So when we get into the Inspectorate Act, states that a heritage inspector may at any time inspect work being done under a permit issued in terms of this act. And for that purpose, they can at all times enter into any premise if they believe there are any violations. So my colleagues, they were referring to the processes, the permit application, and all of those administrative work that is done. So when we receive complaints in terms of violation of the permits or any contravention, we are allowed to go on site and inspect. We have those full powers to inspect work being done under a permit issued by SARA. So the key powers of, once we go on site, we have our inspector's card and have permission to get in. So sometimes we do unannounced site inspections where we believe there is a permit violation. We also document, verify. So we have the right to go to site, take pictures and evidence of what's happening on site, because we know so sometimes it's based on tip get that there is a violation of the permit, or for example, we go to site and they're telling us that the undertakers are using so we have to go on site and you are not allowed to use TLBs in terms of handling human remains. We also issue directives, of which I'm going to discuss in detail, based on our after every site inspection, we go back to the office, and if it's serious heritage crime, that is when we get to open a case, but I will get to that. And then obviously we deal with compliance to ensure that when you're on site, you have the necessary permit, and also you, because of we know that for every permit, there are conditions. Stipulate that this is what you need to do, this is the measurements, this is the buffer zones, this is what you need in terms of the permit condition on site, to see that you have your permit, to see that this is the right undertakers. You hired March and June comes, so we have to assess all of that work being done, and also to ensure that the appointed heritage specialist is there to supervise at all times. So what is a heritage contravention? It's basically any action negatively affecting a heritage resource without the necessary approvals or permits. We heard that for the burial grounds and graves, in terms of section 36, it's 1,200 to apply for a permit, and for developmental applications, it's 5,000. So you need the necessary permit to do any works, be it on site, in terms of graves, buildings, or heritage objects. So as I said, it works with all the units within SARA. So most of the times when we receive complaints is based on unauthorized developments. So these are developments that are happening without following the necessary procedures, without having a heritage impact assessment, without doing the public consultations. So we would have to go on site and assess the situation. We also deal with cases of damage and destruction. So in cases of vandalism, theft, grave disturbances, lack of access, and demolitions. And then we also deal with cases of non-compliance, people who are going on site without the necessary permits, or doing excavations, or defacing or altering without the necessary permit that is required. We will share the presentation. Yes. So we also deal with the illegal export, and we know heritage crime relating to heritage objects, it's becoming a big thing. So it's something that we also deal with within the Heritage Protection Unit in conjunction with the Heritage Objects Unit. And then willful neglect as well. So a heritage inspector, the task and the responsibilities. So we undertake planned inspections of declared heritage resources. We respond to complaints and we facilitate their resolutions. This is a big element within the Heritage Protection Unit, where we deal with communities coming with complaints. We have to investigate, as Mr. Madida was saying, that, you know, we have families coming 20, 30 years later after the case, you know, the transgression has already been conducted, and we have to investigate. And yeah, that is the main thing that we're dealing with within the Heritage Protection Unit, responding to complaints and assessing their resolution. And we work closely with the SAPS to resolve heritage crime matters. And we represent SARA in heritage protection awareness programs in partnerships with stakeholders like the NHC, Freedom Park. Now we're sitting on NALE, which is a forum that deals with specifically heritage crime. So, a grave matter as today's subject, we deal with graves that are located on private property. So, sometimes you buy a house only to find out that there is a grave, and sometimes they demolish the grave without having the necessary permits, or they don't know how to proceed. We had a case where they bought a house and they literally built back rooms on top of that grave. And the lady was aware that there is a grave when she bought the house because of she was desperate then. And then she knew that there was a grave. And they had said that you have to fence it and keep it in situ. And I think the families wrote to us 3 years later that when they wanted to conduct their family rituals, there were back rooms. So now we had to get involved, and there is a case going on because of there is evidence of the grave being present. Okay, so that's private property. And then we deal with graves are located on farms. So this is another big issue where um, farm owners just plow on top of the graves, and now it's vegetation, it's growth, and sometimes there is an issue with access. So we work closely with the CRL Commission in terms of assessing the sites on farms, and it's becoming problematic because of now there is development they have built, or there's plowing, and they will tell you that my grandfather's grave is under that house, and those are the types of issues that we work with within that we come across when we're working with farms. Another big issue, we are dealing with cases from graves on mines. So we know there are a lot of cases that are coming in. We're getting a lot of applications regarding the exhumation and relocation of graves situated on mines, and it's community dynamics. It's very complicated. Graves on mines, it's not an easy, easy issue to deal with. But I think now they are starting to understand the processes. They're starting to understand the importance of public participation, because of you could realize that most of the time they actually wanted to prevent and take shortcuts. And at the end of the day, that shortcut is costing them more money. So we also have graves located on ESCOM properties, spoornet and roads. Sometimes when you passing, you're driving through, you can see some graves on the road. So we also deal with those graves, and there are a lot of cases that are coming in from Central and desecration of graves. So those are the graves located outside of a formal cemetery that we deal with, automatically graves older than 60 years. Finally, the enforcement and penalties. Inspectors act as the enforcement arm of SARA. If structured advocacy or prohibition notices, or if serious willful, will investigate and refer cases to court for execution. This is under Section 51 of the National Heritage Resources Act, and offences can result in penalties ranging from fines to imprisonment. Okay, so other measures and mechanisms that we have in place regarding our site inspection. So when we go on site and we realize that there is a contravention, we would issue out what we call a contravention notice. So a contravention notice will basically be sent to the developer, and it will outline what the contravention is, because of some really don't know what SARA is, they don't know the Heritage Act. So we would issue, say this is what you have contravened and this is what needs to. So there will be conditions in terms of that, and then failure to comply with the contravention notice will result in legal intervention. We also issue out cease works orders. So if we get on site and we realize that there's no consultation, Sorry, I'm just reading the comments coming in. Uh, there's no consultation, or the graves are under threat, or they have there is a buffer and they are just not adhering to anything, we would immediately stop the works. And once you stop a road construction or a development or mining, they start running. They start running because of they are losing money on a daily basis, and they'll call you, Kim, please lift up the order. People are crying. The community is angry because of we have stopped the works. So comply. So we also do compulsory repair orders. So a compulsory repair order, for example, if there are tombstones and they are damaged, we would issue out a compulsory repair order so that you have to repair it. But obviously, they lose the authenticity, and especially when it comes to buildings and things like that, the integrity gets lost. But they do try to adhere to the compulsory repair order because of it is a legal standing order. And then we can also withdraw a permit. So as we said, if there's a permit contravention, we would withdraw the permit. So if you are not adhering to the permit conditions, we have a right to withdraw it. Or if we keep on getting complaints from communities saying they are not aware of this project, they have not consented, they do not know about information and relocation, or just interested and affected parties coming forward, we would have to review the permit but withdraw it, and you would reapply for a permit. And fines and imprisonment. So, okay. So these are just a few case studies. Heritage crime, as we define it, theft of archaeological, paleontological, we know that they belong to the state. Or removing heritage objects from their original sites, a permit. Vandalism, destruction, alteration, removing of heritage objects, all those conclude heritage crime. The export of objects without a permit. Crimes that we deal with: illegal excavation, vandalism and destruction, and theft. Okay, apologies for that graphics, but this is the first case study where they were searching for Kruger rents, and while they were searching for Kruger rents, they exhumed, and those were the remains that were left on site. And the case came to us, and obviously is to track them down, but comes to heritage law, it's a bit tricky. So we have to use common law. That's how we get cases to move. Of that, so as I said, the heritage protection unit of all the units. Here we have the case study of the Steve Biko bronze hands that was stolen, and they were found at a scrapyard, and they were sold for 190. Yes. So, but they were arrested, but we don't know what transpired. I think we need to follow up. Yes, those are some of the cases we deal with, and vandalism. So, Build Environment Unit. This is a national heritage site, and they just decided to extend the house without a permit from SARA. So the Build Environment Unit obviously was affected, and we issued a cease works order and also a compulsory repair order. So they were ordered to had to remove that wall, that extension, because they need to get a necessary permit. And as you can see, this is poor workmen. So you can see that this is just getting your neighbor proper architectural planning. And we know the issue of metal detectors going on site and exhuming, keeping this, and selling them without the necessary permit from SARA. Okay, so this is a case in Rustenburg. That wall that you are seeing there is actually made of stones that were from graves. So it was illegal settlement. So they just started staying there, and there were graves, and they couldn't kill. And they took those stones and they built a wall. I don't know how people can live with that, but they do that. If you can see on the next slide, this is the tombstones, and they made paving with it. So they made paving with the tombstones, and you can just understand, like every day you're seeing that, and you're okay, you're cool, come and collect it. But those are the dynamics of heritage crime. So the challenge is awareness, but some people they do know, some don't know. That's why it's important to have these workshops, not just for undertakers, but the communities at large, and also to let them know the importance of heritage, because of this is their own heritage at the end of the day. If acknowledge this monuments that that Sarah does, the burial grounds and graves, they do it, they demolish it, and they don't take pride in heritage. So it's important to speak on the awareness of conserving this heritage resources. Also, in remote sites, so graves. So those are the challenges that we are facing. People don't know what to do with unmarked graves. You also can't determine the age. They don't know who the graves belong to. So those are the challenges that we are facing. And also another challenge is of resources to monitor online sales. This is applicable to Heritage Objects Unit. So we can't be online. Sometimes we get screenshots from Facebook and they're like, this is on sale on the Facebook marketplace. Are you aware? So we'll have to contact the seller and do our investigations. So, but not all of the time are we online to monitor those sales. Also, the lack of financial and human resources, the lack of knowledge and understanding of the heritage legislation. Most people don't know what the NARA is, they don't know what SARA is, so we can't blame it on ignorance, but that is the general issue of heritage legislation. And also lawlessness. And then also, as stated, the annual crime statistics that are released by SAPS have no reference to heritage crime. So we are trying to build cases where we open cases, but when it comes to heritage crime, there are no crime codes. So I think that's what we are trying to establish so that it has more weight. But when you go to the police station and you're saying you open a case of vandalism, of theft, that is the language they understand. So our important element is to host workshops and public engagements. So this is to ensure that people are aware of the SARA processes that we exist. And this is the processes to follow, and have such seminars, for departments, DMR, there's so many organizations, departments that need these workshops. So, how can you help? Online training for police officers. Even police officers don't know that they're heritage inspectors, but Section 50 says that they are heritage inspectors. And heritage outreach programs, shops, to raise awareness, to help prevent heritage and cultural property crime through signposting of resources, including training and guidance, and to bring together interested parties to identify partnerships and opportunities across heritage and law enforcement. So thank you, thank you, thank you.
Thank you so much, Kim. Please give her another big round of applause. I think that was such a thorough presentation, which highlights the issues that we face, but I think she also raised some very important points for those who are in the industry of the impact that a minor violation or not consulting someone can have on a project. So you may be busy on an exhumation for a mining company, and this project is now costing tens of millions of rands. And every day that a seize works order is affected, the equipment must remain on site. The project is delayed. That increased project costs. So I think there's also a lot of unintended consequences that people need to be aware of when working within the space. I think also the work that she does, colleagues, is quite broad because there are various units. There's built environment. We've got buildings that there's violations for, which she showed. You've got burial grounds and graves, which are vandalized. Of course, again, unauthorized removals, etc. You've got heritage objects, which I think some of you are aware of the Nelson Mandela objects, which went for auction without a permit. That is also something which is a heritage contravention. So it's a very big portfolio, and I think they do a very incredible job. They are very responsive to any complaints, and I think mostly with the funeral association is that even if you encounter challenges or someone who's not being compliant, you're also welcome to raise these issues with Sarah and Kim's unit. So I'm going to open it up again for questions, and then we'll move to the closure. Kim also saved us a lot of time by being very succinct with her presentation. So after this, we'll move to closure, but I will open it up to the colleagues online and anyone present if you have any comments or inputs. Online, okay. I tried to log on so I can see if there's hands, but please go ahead if you're online. We can hear you. I can't see your name, unfortunately, but please go ahead.
Yes, hello, good afternoon. My name is Jennifer Kito. I'm working for a consultancy that does that advises clients on things heritage related procedures, including grave exhumation. So this is more sort of a comment and a query about the grave relocation permit process, but it's also mainly about the permit process between SARA and the Provincial Heritage Resource Authorities, because it's not clear whether the Provincial Heritage Resource Authorities that do have the competency follow the same process as SARA or whether their processes are different. Specifically when it comes to Amafa, I'm struggling to find out how their process works. I do have a copy of their grave relocation exhumation form application form, but it doesn't answer all my questions or my clients' questions about exactly what the process is, how long it takes, how their permitting process works together with the environmental health or the SAPS. So I wanted to ask, is this being addressed in terms of how the different processes for issuing grave, specifically exhumation or damage permits, how they correlate to each other? And if not, is there a plan, or would there be a plan to address this? Maybe having a workshop like this, but where all of the PRAs who are competent present their processes, and then various people who would be interested or would need to know would be able to attend, like this one. And I wanted to also say thank you very much for organizing this workshop seminar, because it has helped me a lot, or helped provide useful information. But I think details on the Provincial Heritage Resource Authorities processes would also help. Thank you.
Thank you so much. That was a wonderful comment, a brilliant question that you're asking, and we will try to address it. There were multiple areas. I'm going to hand over to Kim and Ntate Matida as well to respond. But to say just to give you my input firstly, that you are absolutely correct in that they are the provinces and the national sites or resources which are administered by SARA. And then we've got Western Cape, Eastern Cape, You asked about Amafa, that's KZN, and most recently Lira, who have various levels of competency. And it is not always clear what their processes are. So with SARA, everything is online. But then you may get to ECPRA or Lira, and now you're using a paper-based system. And I know that that can cause confusion, especially if you're trying to be compliant or apply for a permit. So I've taken on your suggestion, but let me give my colleagues an opportunity just to add. We'll start with you, Mr. Matita, and then we'll take him if she has anything else to add. Go ahead.
On some of the points on my response. Overall, whether they are provincial heritage resources authorities or local authorities, the NARA, the National Heritage Resources Act, is where they should find the basis for all of their regulations. I think when it comes to the sort of nuances that may happen within the provinces, because they are competent and they are on the ground in the provinces, they are best able to develop regulations which are in sync with the NARA, but which speak to the specific circumstance within the province. So that's where perhaps you may have those little variations, because it may be responding to what it is that they are seeing on the ground in KwaZulu-Natal or in Limpopo. So as long as it is not in conflict with the NARA and its regulations, then it is something that I think we would look into and accept. I think the second part is that maybe we should have such engagements where we bring them on board so that they can then outline to the public in a similar way their own processes in terms of how they are administering the National Heritage Resources Act, Section 36, insofar as what they are seeing in that specific province is going on. So I think, AMAFA is an entity on its own, fully competent, and maybe there may be things that they are able to specifically respond to. I think we would interject in their response if what they are responding to then seriously conflicts with what we have in terms of the NARA and the regulations that have been put down. Thanks.
Thank you so much. Ms. Kim, you're covered? All right. Again, thank you so much for your question. And we have taken your recommendation on board. I've written it down that we need to expand this. It's not just SARA. There are also provincial prescripts, and we will make an effort to have the PRAS presenting as well. Any other questions, comments? You can just check online EP as well. We have one more. All right. Online, I can't see your name, unfortunately, but please go ahead.
Can I proceed?
Yes, please proceed.
Mine is on limited knowledge on the NARA. I'm just wondering if SARA has a way of monitoring the PRAS as well as the local authorities in terms of ensuring that we implement the act effectively. For example, community campaigns and public engagement. Is there a way that we can monitor these two arms of government that we engage with communities to empower them on the importance of this legislation? Because I would like to assume that majority of our police officers do not know that they can be heritage inspectors, for example, So that engagement, for example, national departments have got what we call compulsory KPIs. I'm not sure if agencies have got those legislative powers to say, PRAS, you need to perform this particular task, and they are compulsory as per the legislation. I give thanks.
Thank you so much. Again, I'll go first, and then I'll give Kim and Dr. Matida an opportunity. To your question about the PRAS, right? Remember, the PRAS they apply to SARA periodically. for competency. And they have to demonstrate to SARA that they have the ability to fulfill what they are applying for. So, for example, with Section 36, that's why not all the PRAs are competent, because some of them don't have the required personnel or equipment to carry out this function. So SARA does it. With Section 35 is another one where some PRAs don't have archaeologists. So SARA fulfills that function for those provincial authorities. When it comes to the local authorities now, this is where there's a big gap. Ntate Matida was referring to this. The devolution or the powers that are given to local authorities must come from PRAs. They don't come from SARA. So if you don't have your PRAs that are fully competent, there is no way that there's going to be that devolution further to your local authorities. So it's a massive gap. And in fact, in the whole of South Africa, there's only one municipality that was ever given any heritage competency, and that was the city of Cape Town. The other municipalities have never, ever had any heritage competency. So it's a massive gap. It's something that needs to be addressed because heritage is closer to the ground. It must be managed at a local level. But again, this is if the PRAs are not fully capacitated, then the local level will also suffer. But let me bring in Ntate Matida and Kim just for further comments. Covered. We covered. All right, Kim? Covered. All right, thanks. Covered. Colleagues, last round, if there's any questions here or any comments online, Ifi, or questions? There were comments. We are responding to the chat as well. All right, colleagues, I do not see any other hands. With that, please give Ms. Kim another big round of applause. That was a wonderful presentation. Thank you so much. Okay, so I think we are on time and we're going to be moving towards the closure of the session for today. I think we had engagement after the presentations. So if anyone has anything that they want to ask, any general questions, you are welcome to, but I'll just continue talking. And if you raise your hand, I'll acknowledge you as well, okay? So to conclude the session, I'm just gonna make about 5 announcements, and then I'm gonna invite Mr. Matida for closing remarks just to end the session. But just a quick reflection on today, colleagues. We had our first presentation from Mr. Matida, where he was highlighting the role of SARA. He spoke about Section 36 specifically, and he spoke about the processes that unfold in the Section 36 process, a broad overview of everything, all right? And then we had Sabelo and Riachile, who Sabelo spoke specifically about Section 38. Okay, so those are your development applications, your power lines, your roads, those that trigger Section 38, and the implications of those on your burial grounds and graves, in which a Section 36 permit is required. And then we had Riachile and the Tokolosh, but she was actually getting into the specifics of what is required for these Section 36 permits. It's very important information, and we will get it to you at the end of this session as well, all right? And then lastly, we had Kim, who spoke about the Heritage Protection Unit, contraventions, violations, the penalties that are that apply to these violations, and also the tools that SARA has in order to manage these contraventions, seize works orders, permit withdrawals, and the consequences thereof. So I think today was the first of many sessions, okay? We will, number one, ensure that all presentations are PDF'd and shared with all of you here today. Number two, very important, Mr. Matida said that the outcome of today is the guidelines, all right? So we want to have basically a simple toolkit that can go to the associations can hand it out to their members, so that if someone encounters a situation and they feel, I'm not sure, they can go to the toolkit, but also they have access to the relevant officials in SARA to directly assist them with these queries. So the guidelines will be developed and shared with the Funeral Undertakers Association. And very importantly, that what has come out now is that we need to be clear about the roles of the provincial authorities. Today we've spoken about SARA. You go to KZN, you may hear they're doing things differently. So that is very important, and it should form part of the guidelines as well. All right, now, in terms of another step to explore with the Funeral Undertakers Association is maybe formalizing our relationship with SARA so we can have a formal working relationship in which you can tell us what expectations you have of us, and we can say we have these expectations of you, and that is just an MOU. It's something we can explore, and maybe one of the outcomes as well from today. And then this particular session with Mr. Matida, when we were planning this, we thought, at first I thought you're going to invite everyone, the mining companies, and he said, no, I want one stakeholder. I want to start with the funeral because there's a gap. We've never engaged with them. And I thought it's a very important first step that he took, but we're going to broaden this session as the years go. So for now, it is maybe planned to be annual, but there's no reason why we can't have online engagement, all right? Something important comes up, there's a policy change, there's a legislation change, there's a very controversial case, and we can meet up online virtually, organize a session. That can happen. Again, we'll send those directives out. But for now, Mr. Matida has planned these sessions to be annual, and next year with the same group and expanding it to other stakeholders as well. So, yeah, I also said lastly that next year's session, we would hope that the funeral associate, those in the industry, will present to us next year as well. So it won't just be about us presenting our legislation, our processes. We also want to know what your experiences are, what maybe you want from us, even in terms of a policy change, a process change. So next year, we will invite you to present to us. And that brings me to the end of my reflections of today. I think you should give yourselves a big round of applause. You've been a wonderful audience. And I'll bring Mr. Matida just for closing remarks, and then we'll move to closure.
Good afternoon, everybody. Thank you so much. I know that after lunch, the heads, people tend to agree, even when they don't agree with you. You see the heads nodding, and you know it's the foot that's nodding. But just a couple of really heartfelt appreciation for standing up and responding to to this session, which is a way of getting to know each other and creating a relationship in terms of the work that we do and the work that you do. You are very important to us in terms of heritage conservation. You are an important stakeholder. You might not have seen it, but you are implementers of the legislation, both directly and indirectly. And so we think that it's time that we put our heads together so that we can see how we can serve our communities, because you do a work that serves communities. We also serve communities. And I think because of that, I think there's a way in which we can find synergy in doing that. We are available as SARA for any guidance, assistance, or queries. I think that we've collected the emails for everybody. I hope you registered, right? If you haven't, please do. Just leave your name, your email, and your contact details so that if we have things that we'd like to reach out to, or if we have questions, our details would be available. We will create a database of everybody that attended so that we retain this contact list for the future coming engagements. My email is nmadida. Let me dictate that slowly. N Madida, it's one word, NMADIDA. Please don't put a B. It's Mandela month. I don't fit those shoes. It's not N Madiba, it's Madida. So N Madida at Sarah. Sarah is SAHRA. All right, not Sarah the lady. Sarah, SAHRA .org.za. So you can get in touch with me on that particular email, and we will respond to whatever it is that we have. I will apologize to my colleagues at Freedom Park. It's not that we don't love them; we love them heartily and deeply. But the little presence that we've got, we will just prioritize our external stakeholders, and whatever's left, then we can then relay those. So please, there is just something to say thank you for being here that Ms. Sengane will give towards the end. But overall, thank you so much. You've been a good audience. You've asked questions, and we've tried to respond. If we haven't, please get in touch with us, and we will do. And really heartfelt appreciation. Thank you very much. Thanks.
All right. So firstly, let me just give a very big thank you to Sarah's Burial Grounds and Graves Unit. Please give them a big round of applause for organizing this session. We also need to give a very big thank you to Freedom Park for hosting us today at this beautiful facility. Sarah's Heritage Protection Unit and Development Applications Unit, please give them a round of applause as well. And the people who you never see, guys, is our marketing and comms colleagues. Those guys there. Please, they make sure that things run smoothly. And lastly, I'd like to thank the Funeral Undertakers Association and all the stakeholders who've come here today. You've taken the time to speak with us, to engage with us, and to build this relationship with us. It is the first of many, and I do hope to see you again, either in person or virtually. Please pass Riachile on the way out, just to receive something. And with that said, the meeting, sorry, there's a hand there. Oh, to myself. All right, no, thank you to me. All right, the session is adjourned. Sorry, ma'am, go ahead. Yes. Thank you so much. Please give a round of applause. All right, so I think today is a very, very important first step. And going forward, I just see this relationship growing. And our doors are open, as Mr. Matita has said. He's given you his contact details. And we will do this annually. And we will broaden it to other people in the industry. All right, with that said, the session is adjourned. I hope you all have a lovely week further. For those of you traveling, I hope you travel safe. And I look forward to seeing you all next year or much sooner. Thank you, colleagues.